Under section 104, burden of proving a fact to be proved to make evidence admissible. Whenever it is necessary to prove that any fact in order to render evidence of any other fact admissible, the burden of proving a fact, that fact is on a person who wants to give such evidence. The illustration explaining the position has to prove that he was yours. A father admitted the girl whose legitimacy was in question was his daughter, but that she was illegitimate. There being a presumption of legitimacy, burden lays upon the father to prove otherwise. In dealing with Pradhanasin woman, there is a presumption that the contract was the result of undue influence. Hence, the burden lies on the other party to prove that the transaction was fair and free. A Pradhanasin woman transferred her land to her son subject to certain conditions as to the maintenance, etc. But the deed was altered so as to remove the conditions. The burden to prove that the altercation was with the consent of the woman was upon those who were trying to take advantage of the deed. An illiterate woman contended that the sale deed which she executed was not read over to her. It was held that the burden was upon the other party to prove that she was made fully aware of the content of the document. Burden lies upon the plaintiff to prove all the points of the right of preemption. A telegram by itself is not authenticate document. It is like a unsigned anonymous communication. Unless a telegram is confirmed by subsequent signed applications, representation or an affidavit, content of a telegram have no authenticity at all. With the railway, contention was that the person who died by falling from a train was not on a bona fide passenger, being without ticket, that it was for the railway to prove that fact. The vehicle was transferred prior to its incident. The fact that insured failed to make an application for a transfer of insurance was to be pleaded and proved by insurer when the claimant is a third party. Where the rented premises were found to be in a position of a stranger and not on the tenant, the burden upon the tenant to disprove the inference of subletting, as he alone had the special knowledge of the fact. In case of a transfer of a property by an ostensible owner, burden to prove that the ostensible owner under registered sale deed was only a benamidar was upon the party who set up a benami. Burden of proof of material impairment to the value or the utility of the building as a result of unauthorized construction or alteration is on the landlord. Where the guarantor alleges that hypothecated goods were lost due to negligence of the creditor bank, onus to prove negligence was on the guarantor. Where the vehicle suddenly went off the road, overturned and killed the victim, doctrine of res ipsa loquitur was attracted and onus was shifted from the claimant to the driver to prove his non-negligence or vigilance. This section should be read with clause 2 of section 136 and with the illustration attached to that section. Section 105, burden of proving that case of accused comes within the exception. In a criminal cases, the burden of proof, using the phrase in its strictest sense, is always upon the prosecution and never shift whatever the evidence may be during the progress of the case. When sufficient proof of the commission of the crime has been adduced and the accused has been connected therewith as a guilty party, then the burden of proof in another and quite different sense, namely in the sense of introducing evidence in rebuttal of the case for the prosecution, is laid upon him. The onus of establishing an exception shifts to the accused when he pleads as an exception. The onus can be discharged either affirmatively, establishing the plea taken by an accused person, or by eliciting such circumstances which would create a doubt in the mind of the court that the reasonable possibility of accused acting within the protection of the exception pleaded is not eliminated. If on consideration of the evidence as a whole, reasonable doubt is created in the mind of the court as to guilt of the accused, he would be entitled to acquittal. In a case where Section 84 was invoked by the accused, it was held that the burden of bringing his or her case under Section 84 IPC lay squarely upon the person claiming the benefit of that provision. It was further held that the standard proof which the accused has to satisfy for the discharge of the burden cast upon him under Section 105 of the Indian Evidence Act is not the same as is expected of the prosecution, which has to prove the charges beyond a reasonable doubt. Where the accused has laid no evidence in a defense to support the plea of the legal insanity, it is open to an accused to rely upon the material brought on record by the prosecution to claim the benefit of the exception. Evidence in defense may be surpluses in a cases where the defense can make out a case for the acquittal of the accused based on evidence adduced by the prosecution. The burden on accused to prove his defense stand discharged by showing preponderance of probability in his favor. Plea of insanity is invoked by an accused. It is for him to establish that fact, but the burden of proof upon the accused is no higher than one which rests upon a party to civil proceedings. When a part of the section of an act has been held unenforceable by the court, it is for the prosecution to establish to the satisfaction of the judge that the case comes within the enforceable part. No onus is cast on the accused to prove that his case falls under that part of the section which has been declared unenforceable. The Supreme Court has laid down in Yogendra Morarji versus Gujarat that the burden of proving defense arises only when the prosecution discharges its initial and traditional burden of establishing the complexity of the accused. Even under this section, the standard of proof required for establishing a defense is that of a prudent man as laid down in Section 3. But within that standard, there are degree of probability. The nature of the burden is on an accused. Accused person is not an onerous, may discharge his burden of proving the charges beyond reasonable doubt. The accused may discharge his burden by establishing mere balance probabilities in his favor with regard to alleged crime. Section 106, burden of proving facts, especially within a knowledge. This section applies only to a parties to a suit. where the knowledge of the subject matter of an allegation is peculiarly within the provisions of one party to a suit, the burden of proof must lie there also. Thus, for example, sale of consignment entrusted to a commission agent, and particulars of those sales are matters which lie especially within their knowledge. Similarly, in a case of servant charged with a misappropriation of his master, if the failure to account was due to an accidental loss, the fact being within the servant's knowledge, it is for him to explain the loss. In a claim for maintenance, the claimant can quote a figure of income on guesswork, because the fact of exact income is especially within the knowledge of the other party. Where a person was found in possession of a gold with foreign markings, the Supreme Court held that burden lay upon him to account for his possession. Action does not cast any burden on the accused person to prove that no crime was committed by proving a fact especially within his knowledge. Nor does it warrant the conclusion that if anything is unexplained which the court thinks the accused could explain, he ought therefore to be found guilty. It does not affect the onus of proving the guilt of the accused. That onus rests on the prosecution is not shifted on the accused by reason of this section. It is only in a cases where the fact proved by the evidence give rise to reasonable inference of the guilt, unless the same is rebutted, and such inference can be negatived by the proof of some fact which in its nature can only be within the special knowledge of the accused, that the burden of proving the fact is on the accused. This section cannot use to shift the onus of establishing an essential ingredient of the offence on the accused. It has been considered by the Privy Council that the burden of proving negligence always rests with the plaintiff, even when the maxim res ipsa loquitur applies. 107. Burden of proving death of a person known to have been alive within 30 years. Section 107 of the Evidence Act 1872 speaks about burden of proving a death of a person known to have been alive within 30 years. This section says when a person is shown to have existed within 30 years, the presumption is that he is still alive, and if anybody alleges that he is dead, he must prove the fact. The presumption is not very strong presumption. It can be rebutted even by the slightest evidence of the contrary. Section 108. Burden of proving that a person is alive who has not been heard of for 7 years. Under section 107 and 108 must be read together, because the latter is only a proviso to the rule contained in the former, and both constitute one rule when so read together. There is no presumption in law that a person was alive for 7 years from the time when he was last heard of. This section deals with the procedure to be followed when a question is raised before a court as to whether a person is alive or dead, but do not lay down any presumption as to how long a man was alive or at what time he died. Assuming that the court could make a presumption that a person was alive for 7 years after he was last heard of, it depends on the circumstances of each case, whether the court could draw such presumption or not. In a case of Kalyan Kumar Bhattacharya versus Pratibha Chakraborty, AIR 2010, NOC 646. It was held that a person was not heard of more than 18 to 20 years, though the defendant claimed that he was writing letters to him. He could not produce any of such letters. The court said that the presumption of his death could be drawn. The distribution of his property among his brothers and sister was held to be permissible. In a case of Puja versus Rai Chandani versus State Bank of India, AIR 2009, NOC 685, it was held that whereabout of an account holder in a bank were not even children file a writ petition for an order permitting to withdraw the money from the account and also to collect the content of the locker. They being not able to file a case of succession certificate. The court said that they could not be denied such relief. They were allowed to collect their inheritance as being heirs of the first degree. In a case of Chammi Narayan versus V.R. Krishnan Iyer, AIR 1998, Karnataka 365, it was held that a tenancy proceeding, an application was made by a mother of the tenant for her addition as a party on the ground that her son was not heard of for more than 13 years and should be presumed to be dead. The court said that Section 108 does not provide any procedure to be followed. Hence, a separate suit for getting the declaration that the original tenant was dead was not necessary. Section 109, burden of proof as to relation in the cases of a partners, landlord and tenant and principals and agents. When the existence of a personal relationship or a state of things is once established by a proof, the law presumes that the relationship or a state of things continues to exist as before, till the contrary is shown, or till a different presumption is raised from the nature of the subject in a question. A partnership, tenancy, or agency, once shown to exist, is presumed to continue till it is proved to have been dissolved. Partnership, once shown to exist, is presumed to continue until the contrary is proved. After a firm is dissolved, the partners continue to be liable to third parties for any act done which would have been an act of the firm if done before its dissolution, until the public notice of dissolution is given under Section 45 of the Partnership Act 1932. Relationship of a landlord and tenant is admitted or proved to exist. It will be presumed to continue until it is shown by affirmative proof that it has ceased to exist. Mere non-payment of a rent, though for many years, is not sufficient to show that such relationship has ceased. The mere entry in the record of tenancy rights register does not by itself confer any right on a person as cultivating a tenant. Where an authority to do an act is once shown to exist, it is presumed to continue until the contrary is proved. Section 182 to 238 of the Indian Contract Act 1872 deals with the relationship of principal and agent. Section 206 provides that the reasonable notice must be given of renovation or renunciation of agency. Section 208 provides when the authority of an agent is terminated.